Limiting Lawsuits by Katherine Horvath and Adam Heller. Law 2150, Appalachian State University, December 2nd, 2014.
Who is involved in business lawsuits? There's a petitioner, the employee or consumer claiming damages, the defendant, business who provides goods and services, attorneys representing the two sides of the case, or the judge who determines if there is a tort and if so, what the damage will be.
As we learned this semester, there are 4 steps in a lawsuit: pleadings, discovery, trial, and appeal. But what are the steps which are not included? Expenses of a trial, keeping the media from being involved, protecting the business's image, and making sure that the employee or consumer is fairly compensated for damages.
Why is this important? We have to figure out who is harmed, and how can we simultaneously protect both the individual and the business's interests. Mark Cuban, the owner of the Dallas Mavericks, was found not guilty last year when accused of trading private information to sell shares to a Canadian internet company. This case led him to create an application called CyberDust that deletes messages after 24 seconds of them being read, basically a Snapchat for businesses. He said this method of disappearing images was made for businesses that face many litigation risks. It can save the business time and money because the messages are not discoverable and are not stored anywhere on the business's computer. Although this may not be the best way to avoid lawsuits, this is one way businesses may try to avoid unwanted intrusion. This could help businesses avoid undue hardship, but it would hurt the individuals who have been harmed by the business that are seeking damages.
Another trending legal issue is employment lawsuits. Renan Gall claims that employment lawsuits have been on the rise in 2014 and will continue to rise throughout 2015. He further explains that the Fair Labor Standards Act, also known as FLSA, is fairly complex and there is quite a bit of unsettled law, which leads to many accidental employer violations. Attorneys usually find that employees have been wrongly classified in these overtime and minimum wage violations, which leads to unfair compensation. Gall's solutions are to conducting wage and hour audits, review company policies, and institute common sense policies.
In a case decided on November 17th, the Court of Appeals of Georgia stresses the importance of drafting a well-developed contract. This is in order to reduce the amount of lawsuits between both joint ventures and business-consumer relationships. They stress that there are some ways that can help reduce these lawsuits from happening. They stress that joint ventures between businesses may include fiduciary responsibilities that include the duty to disclose material facts. This helps information to be circulated and helps reduce fraud. They also stress that terms need to be unambiguous and both parties must read, understand, and obey the contract. With reducing contract issues, lawsuits in businesses may be limited.
A law review states that class action waivers and arbitration agreements have gained traction in recent years. It states that in 2011, the U.S. Supreme Court decided AT&T Mobility LLC versus Conception, a landmark decision that addressed the enforceability of an arbitration agreement and a consumer contract that prohibited class arbitration. The court held that the agreement was enforceable and reversed the lower court's determination that the agreement was unconscionable under California law. This has led to use in employment suits as well.
Lawsuits in the healthcare industry are common to say the least. Whether it is for malpractice or just because the patient is displeased, hospitals and doctors are getting sued. It is believed that limiting lawsuits could make healthcare more affordable because more doctors could stay in practice. The lawsuits hurt healthcare business and cause the price of healthcare to rise. A solution proposed by Roger Stark, a healthcare policy analyst, is to place meaningful limits on the cost of lawsuits. This has helped healthcare costs go down, doctors to stay in practice, and patients to still have a chance at receiving damages.
We know that state and local laws, as well as some federal laws, protect employees and consumers, but what protects businesses? There's a concept called federal preemption, and there are 2 forms, express and implied. Express is where an act of Congress directly includes language that does not allow state and local legislature on the topic. Implied is if the court feels Congress intended to regulate an area of law, or if a state's laws are in conflict with the federal law. An example of federal preemption can be found in the case Geyer versus American Honda Motor Company. Alexis Geyer was driving a 1987 Honda Accord and hit a tree, causing serious injuries. She was using her seatbelt, but the car had no airbags. Alexis sued Honda Motor Company, claiming they had been negligent in the manufacture of a vehicle with no airbags. Honda fought to dismiss the suit because of federal preemption. At the time the car was manufactured, airbags were not a necessary vehicular component. The court agreed with this, and the case was dismissed.
Artificial scientific information has caused an impact on women's perspectives about the drug Mirena, damaging not only the company's reputation but the revenue as well. Former U.S. Attorney General said, as the litigation explosion expands in the country, junk science is producing junk law. The ultimate victims are the American workers and consumers through the increased costs and diminished innovation opportunities. It doesn't just affect businesses, it affects employees and consumers as well.
Tiger Joyce, the president of the American Tort Reform Association, states that every dollar that businesses, large and small, are forced to spend defending themselves against speculative, often frivolous lawsuits is a dollar that won't be spent on research and development, capital investment, productivity-enhancing technologies, worker training and benefits, or new job creation. This is clearly more than just a fight between the business and consumer or employee. It is a threat to economic growth at the state and national levels. He also says that it erodes both the notion of personal responsibility and the respect for the rule of law. In a law review by Erwin Chemerinsky, he states that Congress only can act to remedy or prevent the violation of rights already recognized by the court. He also explains that the United States Supreme Court said that laws must be proportionate and congruent to remedying proven constitutional violations. It is a widely known fact that most businesses operate nationwide. That being said, why couldn't the Federal Supremacy Clause be applied to national business? Congress regulates interstate commerce, so why should it not regulate the lawsuits which affect interstate business?
A lot of the time, businesses have the intent to act ethically, and when something like a woman spills coffee in her lap at McDonald's, or in the case Benjamin Carruthers vs. Red Bull North America Incorporated, where someone sues an energy drink company because it doesn't actually give you wings, it hurts the company, both monetary and potentially the reputation. We chose this topic because we think that the companies that are faced with these lawsuits should not have to lose money or reputation based on the grounds of someone's intent to harm that business and gain monetary benefits. However, we still face the challenge of helping those who have the right to seek damages from businesses. We do not want to limit the freedom of consumers' right to court, and we do not want businesses to be penalized by people taking advantage of the legal system.